About a wonderful, encouraging story, immigration story about a complex case, marriage case, that was approved recently, despite the fact that the client has a big problem on her visa application. For those of you who are new to me, welcome. Come on in. I'm Latoya McBean Pompey, an immigration lawyer in New York, working with clients all over the world at McBean Law. Reach out to us for an appointment with us at 516-866-3900 or at mcbeanlaw.com, where you could book your appointment to meet with us. Also, guys, before you go today, don't forget to also subscribe to our weekly newsletter. We share wonderful Q&As and immigration good news stories and immigration news, okay? Weekly immigration news through our newsletter. So sign up, because you're missing out if you have not yet signed up or subscribed to our free weekly newsletter. Also, for those of you who are catching this on YouTube, subscribe to my channel, hit the notification bell so that you'll be the first to get notice of my videos each week. Now, I want to talk with you guys about a really wonderful story. As I've said, marriage cases can be very tough, very complex. And I've been speaking with you on Facebook over the last week and a half, I want to say, about complex issues involving marriage cases, and giving you guys some tips and insight into how you can manage or get through your case despite the fact that you have complex issues going on with your case. It is possible to still win. Okay, it is possible. Now, it takes strategy, experience, and skills to win in a very difficult, complex scenario. But, I'm hoping that you've been able to get some insights from what I've been sharing with you recently. Now, let's go I'm going to share my screen with you, and I'm going to take you into the story or a testimonial that I hope will encourage you today. And this is a newsletter. In fact, this was our Sunday night newsletter. It went out yesterday, and it covered this story. And it's about a couple who they knew from the very beginning, guys, that their case was going to be a difficult one. And I'm going to share with you the details momentarily so that you could see the complexity for yourself. But they knew, and they met online in October 2020. The wife was in Nigeria and the husband was in Kansas at the time. And right after meeting, they just knew it was going to work out. She's the one, he's the one. And so they immediately consulted with me, and we spoke about the big problem that is on the wife's visa application and ways that we could help them overcome it so that they could be together. Now, they did get married a few months after after meeting, and the big problem is this: on the wife's old visa application, she had applied for a visitor's visa to come to the United States several years ago. And on that visa application, she indicated that she was already married, and she put her ex-boyfriend's name on the visa application. She was ultimately denied a couple of times, as a matter of fact, for the visa. So she's never been to the US. Now, when she met her husband, she knew that this is something that they needed to tackle if they were going to be together. And so when we met with them, we immediately said that certainly we could handle the issues, but here's what it's going to take, or here's what you should expect. Firstly, expect that at the USCIS stage during the case, USCIS is going to ask for that divorce decree, okay, from that non-existent spouse. They're going to ask for that, most likely. Most likely will ask for it. We've seen some cases in which USCIS misses it and don't even ask for it. But we told the client that the government may ask for this. And if they ask for it, it could be a big problem, because if you cannot prove that both of you were free to enter into this marriage, then the government will deny the I-130 family petition. And that's not what you want. You don't want that denial, because if it's denied, it's going to be even tougher to ultimately come together. Now, we told them also that it is possible that a request for evidence, an RFE, will be sent that will ask for this divorce decree. Okay. And so we filed a case in June of 2021. And then in March of this year, USCIS did in fact send that RFE asking for one thing and one thing only: proof of legal termination of that marriage. That marriage that is noted on a visa application from years ago. And the clients did not have this evidence. And so we had to use our experience and skills to respond to this RFE. And when we responded to the RFE, we actually was able to put together a lot of evidence with the client's help, of course, a lot of evidence that she pulled together for us to show that she was never married to to her ex-boyfriend. We also explained and showed what her state of mind was at the time when she applied for that visa application, submitted that information on the application, and why she named him as the spouse. So we submitted the response in July, this past July, and the case was approved on August 19th, guys. And the case has now moved on to the NVC for further processing. But we did advise the clients that, listen, you're not completely out of the woods here yet, because we expect that once she goes in for her visa interview in Nigeria, that the embassy will raise this as an issue of inadmissibility at that time, which they have they can do so. Okay, they can do so despite the fact that USCIS has already approved the case. They could absolutely, at that point, put a pause on things and say, you need a waiver. You'll need this waiver to address this problem. And once your waiver is approved, we will allow you to get your immigrant visa so that you could go to the United States and be with your husband. And so that's what we're expecting to happen. And we have the experience and the skills to even deal with the waiver once it gets to that stage. So I'm sharing this testimonial with you to show that if you have certain problems related to an old visa application and you've met the love of your life and you're ready to come to America and be together here, but but for this visa application that has misrepresentation on it, then you may feel like there's no way this is going to work. I will never get my visa to go to America. It's just not going to work out for me. But I want you guys to know that it is possible for it to work out. Our clients have passed through the first layer of scrutiny, and we're expecting another layer of scrutiny at the U.S. Embassy level, but there is already a strategy to address that. So guys, be encouraged. If you're out there and you're thinking about filing a marriage case, or you've already filed it and it didn't go so well, or you may have already received a notice of intent to deny, or even a notice of intent to revoke an approved I-130, or an RFE that's asking for information that you clearly don't have, guys, reach out to us, contact us, get your appointment scheduled so that we could take a look at that issue and navigate you through those difficult waters. If the government is accusing you of entering into this marriage to get around immigration laws, and that's clearly not the case with you, contact us. We would love to talk with you about that issue as well. Or if you have an upcoming second or Stokes interview, work with a lawyer, be prepared, have someone there with you, and get through that challenge. Okay, guys, comment below. Don't forget to subscribe to this channel. Don't forget to subscribe to our weekly newsletters at McBeanLaw.com. And guys, let me know your thoughts below, and I will see you in the next one. Thanks so much. Bye-bye.